someone's laptop to show video evidence?
I'm sorry, put her in custody right now. You don't approach the bench, come up and approach this bench. You can nod your head. You want, after Bartholomew Granger attempted to kill me and killed people in this courthouse. This isn't people's court like on television, where you can just amble up here and start approaching the court. Soap opera this afternoon.
It's terrible thing. You know better than that. That's like slapping somebody. No, it's really. That's so far off the rules of evidence.
Well, come on, listen, just get to the point. We'll be here all night on side trails. Let's go.
So
This is just a motion to increase.
Not a global
You are
trial.
indicted
Let's go.
for the third-degree felony of assault on a family or household member. Also, this shows that you, in 2016, were previously convicted of a similar type offense. And in the county court of law of Jefferson County. So this now is a third-degree felony. Any subsequent similar assaults made as alleged here are all felonies. And the present bond is $20,000,
That's my understanding, Judge.
which the defendant has obviously not made.
Well, he did, Judge, you took him into custody last week based on my motion
Okay,
to
I
increase
remember
and
that.
gave me an opportunity.
He held without a bond
Okay.
until we had this.
Now, this shows the allegation in paragraph 3. The defendant is accused of having contact with the victim of the offense in violation of bond conditions and holding children hostage in an effort to get the complainant to drop charges, would prove be really terrible.
You know, I would call Amber Robinson. Come on up there.
State.
All right, go ahead and state your name for the record, ma'am.
Amber Robertson.
All right,
That's
you
okay.
need to
I
spell
can hear
it.
her. Okay.
Go ahead and spell it so we can be clear. Okay, and you are the named complainant in this cause number where there is an accusation for family assault, are you not, ma'am? Against this gentleman, Mr. Washington. He's accused of having assaulted you back on December 3rd of 2022. All right. And I'm not going to go into the facts of that particular matter. I want to talk to you about any contact he's had with you since this indictment was returned. Do you understand that? Okay. This indictment shows to have been returned on
April
April
26th.
26, 2023. Has he had contact with you since that time, ma'am?
Yes, sir.
And at that time, was he out on bond to your knowledge?
Yes, sir.
And did you in fact call my office about that sometime in August?
Yes, sir.
Tell me initially what took place that resulted in you calling the office in August of 23.
I went to the orange to pick up my children. I was denying my kids. I had extra hair under my finger. He told me no, and so I got charged and I can get the kids. And I officially called the police. And he told me no, I have no charges because he told me how to go about the situation.
Okay. So was that time frame, was that August of 23?
Yes.
Do you remember the exact date that he had contact with you?
I don't remember the date. I just remember calling you.
Okay, you remember calling me, but as far as did you have contact with this individual, and I'm pointing at Arthur Washington.
Yes, sir.
Is it true that this gentleman in the orange standing before the court, is that who we're talking about, Mr. Washington?
Yes, sir.
And you stated that you all did have contact,
Yes, sir.
and you went so fast, I want to slow down.
Oh, okay.
Okay. The two of you have children?
Yes, sir.
How many?
5.
And what are their ages?
9, 10, 5, and 8 months. 45 months now.
Okay. At that time, who was the custodial parent over these children? And you still are, right? Is there a domestic order regarding the possession time that y'all are supposed to have? That's what I mean.
Yes, sir.
And does it say his time that he's supposed to have
Yes,
and the time you're supposed to have?
yes, sir.
This particular time when you went to get your children, was it your time to have custody of the children?
Yes, sir.
And you went to get them from whom?
I went to get them from the mom, but the mom said he had them. I spent them about it.
His mom?
Yes.
Okay, so that's the paternal grandmother.
Yes,
Is that a yes?
yes, sir.
Okay, you gotta always make sure you give a yes or no answer, okay? So his mom had the children,
Yes, sir.
or was supposed to.
Yes, sir.
You discovered they weren't there.
Yes, sir.
When did contact occur between the two of you, meaning Mr. Washington and yourself, ma'am?
Over the phone.
Okay, and what did he tell you?
He told me about Georgia charges, and then I could get my children back.
All right, so at some point in time, he tells you on the phone, he's not returning them unless you get the children, unless you drop the charges.
Yes, sir.
Did you then in fact try to contact me in the efforts to try to get these charges dismissed?
Yes, sir.
Was it because it didn't happen? Or was it because of this threat that was made against you?
I feel like I went to the job charges earlier, but he was thought to get my children back.
But just because of the threat,
Yes, sir.
right?
Yes, sir.
Is there any chance that what he said to you that you misunderstood it?
No.
Was he very clear about what was required before he would return the children?
Yes, sir.
And ma'am, I put in my motion and I quoted that he was holding the children, quote unquote, hostage in an effort to get you to drop the charges.
Yes, sir.
Were you the one that said that?
What?
That he was holding them hostage?
I did. Yeah, he was part of the house.
Have you been able to get your children back?
I had to go get paperwork and then once y'all picked up, I got my children.
So when he went into custody last week, was when you were able to get your children back?
Yes, sir.
I've done a bit of domestic practice, so I'm familiar with the terminology that's used in domestic orders. Is it fair to say that what he had underneath that domestic order was what's called a standard possession order? Meaning he wasn't supposed to have the children except for the first, third, and fifth Friday weekends? Is that an accurate statement? In the time frame that we're talking about, this was well and outside of that time frame, correct?
Yes.
I have no further questions, Sean.
All right. Understand, you understand that the state has filed a motion to increase my client on the bill, right? And as it relates to factors for setting bills, one of the factors is the nature of the offense and the
That's
circumstances.
not it, bro.
Yeah, I would object to that as relevant.
That's
This is
not
all
a
about
point for her.
conduct.
That's a legal issue. She's not in a position to answer that.
All right. As it relates to the nature of this particular offense, in this particular case, the alleged complaint was made on December the 3rd, 2022. That's correct. Would it be December the 3rd of 2022? All right. And do you remember any Beaumont police officers coming out on the scene on that particular?
And I'm object to going into the facts of the offense. I limited my question specifically to the issue at hand. It's whether or not,
It's, if you're gonna increase
What's
the
the
bond, I
point?
can go into the factors, and one of the factors is the nature of the circumstances of the offense. That's directly out of the code. If he's gonna act that the bond be
The
increased.
offense that he's charged with. Is that what you're gonna go into?
Yes, I think I have every right to go into it.
Well, I thought you were leading into the issues concerning
I'm gonna get there.
the
but
connection, the contact.
I'll get there, but I think one of the factors is the nature of the circumstances of the offense. I can access about that.
Yeah, go ahead.
All right. For this particular offense, this officers from the Beaumont Police Department arrived on the scene
When?
on December the 3rd of 2022.
Probably things. No, I don't think I remember that. I just remember one in November and one in the end of December.
And were you aware that Officer Concones did not observe any injuries while he was on the scene?
Objection, Your Honor. That's just counsel attempting to testify.
What's the
The
objection?
objection is you're attempting to testify. As I was saying, the objection is counsel is attempting to testify.
He's got her on cross-examination. He can ask a leading question.
Just not believe,
Overruled.
I'm sorry.
Go ahead.
Did you know, at least according to the case supplemental report, the officer did not observe any injury on you while on the scene? Did you know that?
No, because what I did was that, they didn't have pictures.
And did you know? Do you remember Mr. Ham asking you about you calling him? And I'll show you as I'm questioning you. This was a handwritten statement that you provided in your own handwriting. Is this in fact your statement?
That's mine.
So basically, as I understand from reading the reports, you told the police officer that my client bit you on the right leg. He struck you on the right side of your face multiple times. And then he also choked you. Is that what you told the police officer, right? Right. But then when in fact, they observed you, there weren't obvious injuries observed on you, is that right?
No, I didn't have injuries. I still have pictures of my car. I actually department the next day, the next week. Then I obviously couldn't see him.
And then you indicated in your report or your statement that the reason that y'all had a disagreement is about a car that you said he stole, that he stole from you. That's what you put in the report, right?
Yeah.
All right, but in fact, he is the registered owner of that car, isn't he?
He forged my name and got my paperwork.
So he's the registered owner, but you're saying he forged your name, is that right? All right, and then this car that is registered in his name, that he is the registered owner of, did in fact on this particular day, you damaged that car. I got you, but for purposes of the nature and circumstances of this offense, which it occurred on this particular time, you damaged the car, and here's pictures of the damage that you did to the car on this day. Is that correct?
Object to all that, Judge. None of that's in evidence that he's got before the witness.
Overruled. Go ahead.
Is this damage to the car on the date of this particular case that you did?
Yes, because he was getting in the car and I had to literally kick and fight him off. And so, yeah, there's gonna be damage in the car.
Okay. So the damage that was done to the car on this particular day, to the windows, to the inside of the car, that was damage done by you. I marked this as plaintiffs, not plaintiffs, I'm sorry, defendants, exhibit A. And that's pictures of the car that she damaged on the date of the.
How many photographs?
1, 2, 3, 4, 5, 6. And I asked that they be admitted in the court, look at them the record. And let the record reflect that I'm showing opposing counsel that the pictures that I have.
I'm gonna object to the foundation on these, Your Honor. There's nobody that's testified that these are true and accurate copies of what they purport to be.
She did, I'm sorry.
I did not hear her make that statement,
inferred.
nor did I hear that
She
question
inferred.
asked.
It's to the satisfaction of the court, they're admitted.
Here you are, I asked that you look at them.
I don't need to see them.
You don't want to see them?
Nope. I don't think that's really fundamental to the whole subject matter of this proceeding. Grand jury indicted with the information they have. We're gonna stand by that. They would have investigated it. They decided that there was probable cause to believe he committed the crime. I'm here more concerned about this standard bond condition order that I and the judge next door authored, which states the defendant shall not communicate either directly or indirectly with the complainant of the pending offense.
Nor shall the defendant go near any residence, school, job site, or other location frequented by the complainant. That is catastrophic to this court if you fail to follow this condition of probation. And if it's found that someone is not only attempting to contact, but attempt to manipulate the investigation or scuttle the investigation that was brought by this grand jury, then they will be dealt with severely.
Okay,
Go
so,
ahead.
so the report is made on December the 3rd of 2022. You testified that you had called Mr. Ham regarding dismissing the case, and you said Mr. Ham told you that he would not dismiss the case. Is that right? Is that right?
Yeah.
Right. And but that's not the first time that you reached out to anyone about dismissing the case. In fact, didn't you?
What does that have to do with the bond conditions that were violated allegedly?
Well,
That's what we're here for. We're not trying this case right now. I've heard enough about the underlying facts of the case and what the.
because I think
But it goes to what?
it goes to exactly, his allegation is that he is putting pressure on her to dismiss the case. That's one of the things.
Let's go into that.
And
Why don't we
what
go
I'm
into that?
saying-
That's what the motion is.
But what I'm saying is that in January of 2023, he was not even in custody. And about this particular case, he reached out to the police. She reached out to police and said she did not want to pursue criminal charges. And I have.
I'm
that
sorry,
police
it
report.
would be for the executive branch of government to decide, not her.
Right, but the point that
Let's
I'm
move
making,
on to the point, which is, did he violate a condition of
he did
bond?
not.
Let's deal with that.
Right, so my point is that the state is alleging that somehow he's pressuring you, but when this case first started, you wasn't under any pressure to say that you did not want to pursue charges, right?
Only because I was having conviction with he made me home, and I was on a heavy medication, and then I called and told them after I was headed home.
Then,
Him.
so then a month later, you changed your mind in February. Was that because the reason you're making up these allegations is that he has a new girlfriend who's in the courtroom right now, and you're mad about that?
I'm gonna object to the wording of that question, Judge.
That's not a legal
Assumes
objection.
facts.
He's not making a legal objection.
It's good enough for the court to sustain.
All right. Isn't your motive for lying today is you're upset that he has a
Wait.
girlfriend?
What's the lie?
The lie is that he in turn is contacting her and threatening her if you don't drop the charges.
That's the issue of this case, yes.
Yes, and that's what I'm saying. She has a motive to make that up, and I'm asking her about that motive, and that's very relevant.
Do you deny that or agree?
Denied.
Next question.
Well, in fact, are you aware that he does have a new girlfriend?
I have a new boyfriend, so they have nothing to do with me.
For purposes of contacting you, at what point are you aware that he's taken into custody in this particular case?
What?
When does he go to jail in this case?
I don't even know, Jay.
She doesn't know.
All right.
Ask your next question.
For purposes of contact, do you know that the judge required him to wear an ankle monitor when he was released on bail? Did you know that? Did you know that, to my knowledge, the probation department has not given us anything, and nor has it been pledged by the state that he.
Wait. Your question is, to my knowledge, she wouldn't, unless she's a brain surgeon or can read your mind and thoughts, she can't answer your question. Rephrase it.
I'll rephrase it. Do you know whether or not he has violated any of the conditions of his ankle monitor?
That's for me to decide, not her.
Do,
Next, let's get to the issue.
okay, for purposes of contact.
Come on, we got a lot to do today, and now we're far afield.
Do you know, has he made any calls to you on your cell phone since he's been released from jail? Any calls?
I told you about the time. Who was that? I don't know. I ain't about to answer because I don't know which day, which time. I don't know. I don't want to answer it wrong or right. I don't know.
She doesn't know.
All right, so you don't know if he's made any calls. The kids, how did the kids get to his residence where he had an ankle monitor? How did they get there?
I was dealing with his mother because I was dealing with his mother, and then I guess the kids were with him because she said she didn't have nothing to do with it. I wasn't supposed to have contact with her or with my kids. And I said, how I didn't get no paperwork. And that's when I had to go get paperwork from my talk boy. But I don't remember this about. none of this.
Then in fact, you dropped the kids off to his home.
To his mother. I didn't know who he was.
So you dropped the kids to his mother, is that right?
Mhm.
And then his mother brought the kids to his home, right?
I don't know. I don't know anything. I
So
don't know about that.
in the state's allegation where it says that he's having contact with you, then you don't remember any phone calls. Let me ask you a different question. At any time, does he show up to your residence? At any time, does he show up to a residence where you are? At any time, does he show up to any place that you employ?
My forehead.
Is there any time that he shows up to any function or place where you at?
I told you the last time I talked to you when you told me to drop the charges. And that was it. I don't remember nothing else further than that, sir.
The date that you say he told you to drop the charges,
I'm going to therapy behind it. I don't remember none of it.
was that a telephone call or was that in person?
It was over the phone. And you told me that. Then I called, once I left the residence, I went over to the police, trying to get my keys. Once I left, that's when it happened. And then I called, him and told him I said, hey, I got to drop the charges. That's it. That's all I remember.
Now, the children, the second part of his motion is holding the children hostage. The children that you said that you dropped off to his mother and the mother in turn dropped them off to him. At any point, did you go to his home to try to get these kids?
I don't know, police officers. I had police officers meeting to talk to the mother
At his house?
at the mother's house.
Okay, then what happened when the police?
They
came to his
told me
house?
no, and then they was like, she don't have anything to do with it, it's the dad, and he was telling me no, but even though I had paperwork, but we have a custody order, not somebody. We have a custody order, that's withholding a child, it's a crime. If you want to get the custody order, then there is not.
But the kids is not at the mama's house, it's at his house now, right?
I don't know. I don't know.
So did you ever take the police from his mother's house to his house where the kids were?
No, what it is, I don't know.
So you don't even know where he lives?
I don't know. The last time I talked with him was when I went out there and he told me he couldn't talk to me. And he was talking to me after he saw recording
So when is the last time you went to his house?
to get my children. I don't remember that. I want police.
I passed the witness, I got.
And
No further questions of the witness, Judge.
okay, can this lady be excused? You're
Please.
excused, thank you, ma'am. Next,
Stay abreast.
what says you?
I call
Hello,
Tammy Aguilar.
A matter of judicial
yeah,
economy, Judge, I'd ask for a proffer so we know what we're about to hear.
No, I don't have any legal basis to give.
I'm
you.
asking you to do that so I can determine whether we're gonna waste time or not. Summarize what you intend to present, please. Thank you.
Well,
Just summarize it, and we'll hear from her. Summarize it. Thank you.
well, I think that.
Don't look at him, go over to me. Come on, just
Well, he's looking at me.
summarize
I'm looking at
it,
my-
please.
Just looking.
What do you intend to present here?
What I intend to present is that she is the mom that the lady was referring to where the kids were dropped off, and she has direct knowledge that my client did not contact the lady and did not.
Okay. Raise your right hand. Do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. Your witness, go ahead.
All right.
Sandy T-A-M-O-Y. Aguilar, it's E-U-G. I-L-L-E-R.
All right, let's deal with the 2 points that Mr. Helm makes in his motion. The first one is that your son is accused of having contact with Mrs. Robinson upon him being released from jail. So let's deal with the first one. Do you have any knowledge as to whether or not that's true or false?
That's false.
How do you know that that's false?
Because, my son is at our house in my home. And, she brought the kids off to the house.
Okay,
And, you know, he know that he couldn't have no contact with us, so he hasn't been answering calls. He hasn't been texting her back or any of that.
now when you say he hasn't been texting her back, has she texted him to your knowledge?
Oh, yeah, she had texted me, my son, and my daughter.
And why is she texting you, your son, and your daughter? Why?
Just so that-
Objection. Shit, it calls for speculation.
Tell us if you know.
Yeah, because, she keep on saying like, we don't want to give her a kid and stuff like that, but that's not so. My son enrolled the kids in school, she dropped the kids off, she had an issue with her grandmother passed away. She wound up, having the kids come to the house, and my son, even with the ankle monitor on, because he had to call the people and tell them, where he's going and what have you. He enrolled the kids in school, she didn't have the kids enrolled in school, the kids was going to school, the kids.
Objection, Your Honor, this is just going into a narrative.
Yeah, she's repeating herself now.
Okay, so in terms of his second point, where he says in his motion that my client is holding the children hostage in the effort to get her to drop the charges, do you know whether Mr. Ham is wrong in his assertion in that motion?
Well, actually, yes, because my son and the kids were at the home with us. Like, they didn't hold him hostage. He wasn't holding them hostage. It was going to school and everything like that. He had arranged for them to go to school because the mother didn't have them in school. And then he knew that they couldn't be together. And I was calling the Orange Police Department because we live in Orange, and I said, she kept coming to the house. She kept coming to where he is at.
Do you know whether or not this lady has made false allegations against your son?
Oh, yes, most certainly, yes.
And do you know whether or not she has a reputation for being honest or dishonest?
Very dishonest, yes.
And do you have an opinion as it relates to her character?
Yes, I do. I think that she have mental issues. She got bipolar, schizophrenia. Also with the kid and my grandkids, my son got his children because he called CPS because she has some other
Objection to
kids
the
outside
narrative
of
form of the
that.
answer,
And-
Judge.
And they,
Sustain.
and they,
Hold on, I just
sustain.
sustained,
Okay.
you need to speak, quit speaking.
Oh.
How do you know she's schizophrenic?
because,
How do you know that?
cause she told us, I mean, over the years, they've been together like 10 years.
What did she say?
She said that she had mental health issues and she's been having, mental health issues since she was a kid.
Okay,
know,
but
so
how did
She
she,
got a lot of trauma.
how did you diagnose her with schizophrenia?
She told me that. Yeah, she
okay.
told me that. And then
But you
also,
didn't.
she told me different stories about,
Hold on,
okay,
you like to talk, don't you, over others?
no, not over.
Don't do that. When I speak, you stop.
Most certainly.
You have absolutely no medical training on psychology or psychiatry, do you?
No,
Okay, go ahead.
Right, but you don't need any training in psychology or medicine for a person who has a mental illness to tell you they got one, right? And a person doesn't need any kind of training at all, right?
no.
And since that's the state's case, if he called her, I haven't called her, so I can call her to testify where she got mental illness. Now, we can put on the stand.
Objection to the argumentative form of this question, Judge.
What's the point of that question? She's gonna agree with you that you can do that under the rules of evidence? That's not for her to say.
Well, I
Come on,
just,
let's just get to the point. We'll be here all night on side trails. Let's go.
so,
This is just a motion to increase, not a global trial. Let's go.
so with her mental illness, did that factor in as to why she's making up these allegations?
Yeah.
How does she know that?
Well, she knows her. She just,
She doesn't know. That would be for Dr. Grapan to analyze and decide.
I asked a different question then. The lady that's in the courtroom to my right, do you know whether or not your son's relationship with her has anything to do with her making up these allegations?
Objection, speculation.
I asked, did she know?
How would you know that? Unless are you a mind reader? first?
No, I'm not a mind reader,
Okay.
but so
How
many
would you
different
know?
actions have happened.
When
She
I
broke
speak,
the car.
stop.
Okay. It just
One
so
more time,
much.
one more time you do that, you will be held in contempt of court.
Oh, thank
Because I get the feeling you like to control. Are you through? Can I speak now since I'm supposed to be in control of this hearing?
you, most certainly.
Is that okay with you?
It is. Most certainly.
Answer his questions, please. Don't take over the hearing. Go ahead.
All right, do you know whether or not the lady in the courtroom has factored into her making up these allegations, your son's relationship with her? Do you know? Okay. And tell us, how do you know that?
Objection, it's irrelevant, Judge. It's
Sustain.
So at the end of the day, and I'll pass you, at the end of the day, are you saying that your son, to your knowledge, did not hold any child hostage and threaten her to drop charges in this case?
Not at all.
And as it relates to him having contact with her, is it your testimony that she has been the one reaching out to him?
Yes.
Is that right? And I don't know who that is.
Go ahead, ask your next question.
And
Hope that didn't blow up.
in this particular case, once he made it clear to her that he was moving on, was she upset about that?
Yes.
Objection is to relevance, Judge.
I tried to really.
Oh, sir,
I'm sorry, I keep going. And once he made it clear to her that he was done with her, was she upset with him to the point that she would lie?
Yes.
Pastor, with
anything?
No, I don't have any questions.
Your excuse next.
Thank
I'll
Who
call
else?
Dontavia Pryor.
I would again ask for a proffer so that we can limit what is brought out, Judge. We'll make sure we're dealing with relevant questions.
We haven't, we've really pretty much skirted away from that, haven't we?
I'm still doing my best, John.
Well, he's sitting quiet. Isn't he?
What did you just say?
He just tries to interrupt me. With no-
Raise your right hand. Do you solemnly swear or affirm any statement you make today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hands. Let's get to the point.
I'm just gonna deal directly with what he put in his motion. Oh, go ahead.
Dontamia. My last name is Pryor, Pryor.
All right, do you remember when your brother was released from jail on this particular case out on bond?
No, sir.
All right, do you know, well, I know you don't know the specific date, but do you know whether or not he was initiating any contact with Ms. Robinson or vice versa, she was initiating contact with him? Do you know?
Yeah, she was in the shooting contact
Okay, how do you know that? What was she doing?
because I've seen her literally come to our house. She began to harass me at a point, texting me about flat irons and some stuff I had borrowed from her, and also saying that I had stolen her car points and that I needed to pay her money. If not, I would get charges pressed on me.
Okay, so she is texting you, she's texting him, reaching out to your mom, right?
Yes, sir.
And while he's out on bond, to your knowledge, is he trying to make contact with her?
No.
Could you tell the judge why she's doing that to your knowledge?
I believe that she's mentally incompetent. I think that when she doesn't get her way and that when he says, I don't want to be with you anymore, she tries to force and abuse him and abuse the power of the law, and manipulate them and say, you don't want to be with me, fine. I'm gonna say and lie and do all these things, to make it seem that you don't want to be with me, you go to jail. That's basically what she does, and she tried to do it to me as well.
All right, and then when Mr. Ham writes in his motion that my client is holding the children hostage in an effort to get her to attempt to drop the charges, is that a false statement in this motion?
Yes, sir.
Why is that false?
Because he had an ankle monitor on at the time. If he violated anything with the ankle monitor, his parole will be notified. He never left of our knowledge, so there's no point in believing that because I mean there will be proof, like there's no proof. He never left the house. And then also at the time, we only had one car, which is the car that was stolen, that he keeps saying, that's my car, that's my car. We only had one car at the time. I just recently bought a car. I didn't have a car, my mom didn't have a car. We're
Objection
using
to the
one car.
narrative form of the answer, Judge.
We're using-
Sustain, asking a question and answer form. Go ahead.
So I guess let's go straight to the point. The long and short of it is to your knowledge, did he at all hold these kids hostage?
No,
Okay, did she make any efforts to pick up the kids from y'all?
no. She didn't make any efforts up until it was time to come to court. She came to the house and my nephew ran out and then that was her drive, like, oh, he stole my kids, I can use it now.
And do you know why she dropped the kids off to your mom?
And she can't handle them, honestly, that's really why, she always has been like that. She can't handle the kids on her own, so she called them back on. And then once he don't wanna be with her, she starts calling the police and saying, you're going down basically, because you don't wanna be with me.
All right.
Anything else? Any questions?
I do have,
Go ahead.
are you aware of a domestic relations order regarding these children?
Yes, I'm aware.
And isn't it true, ma'am, that underneath that domestic relations order, that that lady is one that has custody of the children?
Yes, she has.
Is it also true that since August 8th, the time in which she claimed that he was holding these children hostage, that he in fact did possess the children from that date up until the time in which he was arrested last week?
No, that's not true.
So that children were not with him
They were
from
with him,
August,
but-
hang on a minute. They weren't with this man or a representative of his family from August 8th up until the time he was arrested last week?
The kids were with us, but she let them be with us.
The question was where the children were. And the question and the answer is they were with either him or his family from August 8th, when she claims that he was holding them hostage, up until when he was arrested. That is a true statement. It is a true statement. The children,
Yes,
Judge, he's badgering the witness.
Overruled.
your answer was yes, right?
Fair
yes,
opportunity.
and I held hostage.
I understand you disagree with my wording, but the facts
Yes, they
are,
were at our home.
the
Yes.
facts are they were at your home.
Yes.
Thank you.
Well,
That's
Mr.
when,
Well, Mr. Ham said he did family law. In those same orders, you have a standard possession order, but it also says as they otherwise may agree. That's also in these standard orders. So as they otherwise agreed, she left the children. with you
objection, Your Honor,
guys.
this is an argument,
Did
not
she
a
leave
question.
Did she leave the children as otherwise, since he said he did family law, you know that, that otherwise agreed, she left the kids with him for that period of time, didn't she?
Yes, she did.
Right, and that's a relevant part of the order that he should know about.
Objection to that sidebar
Why
comment.
would you do that? Why would
I'll-
you
I'll
just
strike
say
that
that?
question.
That's terrible thing.
I'll strike
You know
that
better than that. That's like slapping somebody. No, it's really, that's so far off the rules of evidence. I know you're better than that.
I'll retract that.
That's not
question.
professional.
In this particular case, were the kids with you guys because she couldn't help?
Objection, that calls for
Overruled.
conclusion.
Go ahead, answer.
Yes, sir.
All right, anything else?
Pass the witness.
No further
Anything?
questions.
All right, you may be seated. Anything else?
Just one question from this lady right here. And her name is Malaysia King.
And raise your right hand. You solemnly swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Lower your hands. Go ahead.
MALXYS.
Well, state your name for the record.
Malaysia King.
Right. On the issue of whether or not my client was having contact with Ms. Robinson or holding the children hostage. Do you have any knowledge about this?
No,
All right,
he wasn't on my stage.
right. But when he started dating you, did you see a change in her?
Yeah,
And what was the change that you saw in her?
the angry emotions, she jumped in my DMs on Facebook and just messaging me a whole lot of different stuff. This was whenever we first started dating.
Okay, and what was she telling you?
Objection, Your Honor, to the relevance.
Recall.
Objection relevance.
Sustain.
Do you know whether or not she's made this up because she's jealous of you? You can tell me if you know.
Yeah,
All right, and are you asking the judge not to increase his bond because he has not been contacting her and she's making this up?
yeah.
All right. Pass the witness.
No
Anything
questions.
else? You are excused. Next. Anything else? Anything? No? No?
Nothing further.
All right. Okay. Okay, the court has heard enough here this afternoon to make my decision. The state's motion to increase bond is granted. The probable cause affidavit in this case states that the officer who investigated this case saw the victim with injuries and that her statements to him corresponded with the injuries that he observed. The grand jury investigated this case, deemed probable cause existed for this indictment. In this soap opera this afternoon that we've heard, the gaggle of witnesses that the defense has presented really don't have anything to say that refutes this probable cause affidavit in this case. It gets down to obviously almost a team sport this afternoon. Who's wearing the jerseys? How many more jerseys on one side can we produce? That's not the test. It's what this court believes rational and reasonable. One witness can carry the day. In this case, the court is going to believe the complainant, since the police officers who invested this case also believed her in their investigation. I find that the defendant, there is probable cause to believe in ponderance of the evidence to show the defendant has failed to honor the standard bond conditions as set forth by the criminal district courts in Jefferson County, Texas. As number 3, the defendant shall not communicate either directly or indirectly with the alleged complainant victim of the pending offense, nor shall defendant go near any residence, school, job site, or other location frequented by the alleged complainant victim. Here, the evidence shows not only was contact made and communication made in violation of this by the defendant, but the motive is to attempt to manipulate and change the grand jury's direction that it implemented under law. What we're doing is the law is proceeding, but when the parties feel as though they can behind the scene try to manipulate the direction that the law is headed through the lawful steps in an investigation, then they are manipulating and trying to control the law, which the law does not allow. We're going to let this thing play out properly under procedure and rules of evidence, criminal procedure and the penal code. The defendant's bond is revoked, no bond at this time, as the defendant has violated, and there's no reason to believe that he wouldn't attempt, nor people on his behalf attempt to manipulate the facts of this case through this investigation. And he will be kept in custody until this trial proceeds. Anything else? That is all. I have what are we going to do in Washington? Yes,
That's a
that's
problem.
I mean in Ronald Barn.
Excuse me, Judge. Am I able to use someone's laptop to show video evidence?
I'm sorry, put her in custody right now. You don't approach the bench.
Oh, she didn't know.
I'm sorry. This is not the way you do things. Is this your witness? You don't approach this court and defy this court. Take her into custody right now, put her right over there. Talk to her about what's proper and what's not proper. You don't come up and approach this bench. You can nod your head. You want, after Bartholomew Granger attempted to kill me and killed people in this courthouse, you have to understand the rules of behavior have changed. You don't approach this bench. You don't try to influence this court. And we have bailiffs we have 2 bailiffs are guarding us, me and the other lady next door, because we are in a heightened sense of security. You just can't approach the court. We do it under the rules of evidence and hearings. You had a chance to be heard. If he wants to supplement the record and ask for another hearing, we got other things to do, but you just don't approach me, whether it's here, outside, I'm guarded. There's just been too many acts of threats against this court's life. And I've got a family and I've got a sworn duty to follow the rules. This isn't people's court like on television, where you can just amble up here and start approaching the court. It has to be done in a proper basis. Okay.
This goes with the file.
Talk to her about what
Oh, that'd be fine.
Was this the one that you just introduced?
Mhm.
Here, put this in the file. Talk to her about the proper method. If you need to do something, ma'am, over here. If you need to present the court something, do it through this man who called you as a witness. Okay, and then there won't be any problems, but you just don't amble up here. You're lucky that the bailiffs let you come that far. Normally they don't. People get intercepted who amble up here by themselves.